Hello, everyone. This is the second English session of interview. I'm excited to talk about Anselmo Reyes, Justice Anselmo Reyes, today as the second interviewee. Justice Anselmo Reyes currently be an international judge of the SICC and a visiting professor at Dosha University in Kyoto, and as you may know, formerly a judge of the Hong Kong High Court. And interviewer, Tonedachi, Ms. Natsumi Tonedachi. She's a TMI Associates member and specialized in business, both in international and domestic. She took a course taught by Anselmo at Chuyo University last year regarding international arbitration. I will hand over Natsumi about this interview, and I will probably skip putting in sometimes if I have question. So Natsumi, please go forward. Thank you.
Thank you for the kind introduction. I am honored to interview Justice Anselmo Reyes at this session. I understand that you have a lot of experience as a judge, both at the Hong Kong High Court and the Singapore International Court. In this session, I would like you to focus on your career and experience as an arbitrator. In my understanding, you became an arbitrator after your retirement at a Hong Kong High Court. And my first question is the reason why you become an arbitrator.
Thank you very much, first of all, to JIIART for inviting me for this interview. You asked me to separate my experience as a judge from that as an arbitrator, but I don't think that is possible because the two are closely related. You've asked me why I became an arbitrator after stepping down from the judiciary. Although it was a privilege to be a judge of the Hong Kong High Court, one of the difficulties of being a judge, for obvious reasons, is that one is constrained in what one can do. If you have a lot of projects that you'd like to try out in life, you have a lot of projects in mind, you can't do that as a judge, because as a judge, to some extent, to a large extent, you have to be secluded, sequestered from the public, in order that you are impartial and unbiased when you hear cases. So after 9 years, I stepped down from the judiciary in order to be more free to explore or to try out particular projects that I have in mind. But I still have to live, I still have to earn a living, I have a pension. And so there were two things that I could do. One, I became a lecturer, a teacher at the University of Hong Kong. I taught law. And the second thing is I went into arbitration. When I say the two things I could do, what one can do after one is a judge is very limited. Under Hong Kong's practice, before you become a judge, you give an undertaking that after you leave the judiciary, you cannot practice again as a lawyer. In other words, you cannot give advice on matters of Hong Kong law to a member of the public or a sector of the public. So I couldn't go back to becoming a Hong Kong lawyer. I'm allowed to become an arbitrator. I'm allowed to become a mediator. I'm allowed to provide dispute resolution services to parties to help resolve their disputes. And so that's why I became an arbitrator. One, to live, two, to continue doing what I've been doing, providing dispute resolution services in a more free, less constrained environment than one that has when one is a judge.
Thank you. And so please share some arbitration cases which you are impressed in your career, your experience.
It's easy to think of arbitration as involving large cases. International commercial arbitration is involving cases of millions, possibly hundreds of millions of say US dollars. But actually, there are quite a lot of small international commercial arbitrations. For instance, the average shipping arbitration is really worth maybe no more than 100,000 US dollars. That's pretty small, relatively speaking, but there are many such arbitrations. You asked me to talk about arbitrations that I have that have made an impression on me in the course of my practice. It's difficult to be very specific because arbitrations are confidential. But I can say that the sort of arbitrations that I've found most pleasurable are the small ones. Why? Large arbitrations, large construction arbitrations, which I've also done, typically they involve a lot of money, yes, but they involve a lot of disputed facts. And so a lot of your time is spent in fact-finding, reading witness statements, sifting through documents, weighing the evidence, the factual evidence, on the balance of probability. My real interest is, however, in questions of law, pure questions of law. And those are more likely to turn up in these small, especially shipping arbitrations, where usually the facts are not really that much in dispute. The ship arrives at a port. For some reason or other, it's unable to discharge immediately. It hangs around in port. There may be lay time or demurrage problems. There may be problems with the cargo. There are documents that relate to this. The facts are relatively clear. What is in dispute are matters of law, points of law. The meaning of this or that phrase in a charter party, whether an arbitrator can do this or that as a matter of procedure, jurisdictional questions, that sort of thing. Neat questions of law. And those I find interesting, those I find most exciting. It's different from handling messy questions of fact.
In my image, like those shipping cases are like looks like similar to each other, but is each case interested you?
I used to think the same way. When I was a judge, I was in charge of the Admiralty list, which therefore dealt with shipping cases. In Hong Kong, the typical shipping case is usually always the same. It's about the misdelivery of cargo. Cargo was delivered at the port of discharge without presentation of bills of lading, or the cases had to do with cargo that was badly damaged in the course of the voyage. And the question was, who's liable for the damage? Those types of cases, yes, they are the staple of cases when I was a judge, especially in charge of the Admiralty list. Sometimes you'd get procedural problems in the Admiralty procedures, but otherwise the typical question was the same. Since becoming an arbitrator, I found a greater variety of legal questions arising. Questions on the interpretation of points in charter parties. You have questions on cargo and cargo badly delivered or misdelivered. Yes, you still have that, but you have more legal questions, terms of bills of lading, whether certain parties are bound or not bound. Much more a wide range of questions arise, and therefore there's greater diversity in the sorts of matters that you deal with.
Thank you. So I'd like to move on to the next question. And these days, we have to use online technology in order to conduct international arbitration due to COVID-19. And I want to know your thoughts about how COVID-19 impact on your practice.
I've spoken about this very recently on the 28th of May at the ICC Asia conference. And there, in my keynote speech, I echoed what the Master of the Rolls, Sir Geoffrey Voss, said in England during London Dispute Resolution Week a few weeks earlier in May. he said that as far as he was concerned, in matters of litigation, commercial litigation, cross-border, international commercial, cross-border litigation, online was the way of the future. If all we do is use Zoom and WebEx and send PDF files to each other, he didn't believe that we were taking full advantage of the remote technology that COVID-19 has shown we can use for dispute resolution. I said that for online, online dispute resolution, through arbitration online was the way of the future, and we should be exploiting that. We should be looking at more ways to use remote technology for the future. I pointed out that there was a certain nostalgia amongst many, including many experienced arbitrators, going back to pre-COVID-19 ways. In other words, okay, you can use remote technology for interlocutory matters, case management conferences, pre-trial reviews. But when it comes to the substantive hearing, that's got to be face-to-face, so you can see the witness. You, as arbitrator, can see the witness face-to-face, eyeball to eyeball is the expression usually used, and evaluate the truth or falsity of the witness's evidence that way. I thought that was nonsense. I thought there was no difference in evaluating a witness's evidence, whether done remotely, in the way we're talking to each other now, or face-to-face. And I thought we had to take advantage of the fact that remote technology has shown there is a better way to do arbitration. There is a more cost-effective way. We don't all have to be in one place at the same time. With remote technology, we can have asynchronous hearings. We can have ways of using technology to facilitate parties having to travel. We can lower our carbon footprint. So I think we should be exploring ways. Now let me give one concrete example, building on what I said at the ICC Asia conference. Let's take JIIART. JIIART is supposed to research into the ways that arbitration can become more effective across borders as a means of dispute resolution. Well, one way it can do that is to develop an online platform for cross-border dispute resolution. Now, what do I mean by that? We could have, or JIIART could, through its connections with the university, especially Chuo University, hopefully in connection with Doshisha University, the university where I teach, and I also teach at Keio University, in association with these universities, using Japanese know-how, develop a platform whereby, say, one can open a file, an electronic file, with an arbitral institution. You can have an app, let's say, where you open a file with an arbitral institution, if you're a claimant. You can put in details of your claim, and that's what goes in as, quote-unquote, your notice of arbitration. The respondent then responds on the same file. Each point, each matter of fact, each point of law, each issue that you've identified, a reply, there's a little field, a space in the app where you, the respondent, fill in your answer, your response. And then perhaps it can go once again to the claimant to fill in another field to what does the claimant reply to all of that. From time to time, the arbitral tribunal can check this electronic file and then give decisions on matters as you go along. If that's the case, then at the end of the day, there'll be a substantive hearing. Parties can attach videos of the evidence, the live evidence that they want, including cross-examination. The arbitrators can study that. If the arbitrators have questions, the arbitrators can arrange to question or cross-examine a witness. Those videos can also be attached to the electronic file, and so on. And then at some point, the arbitrator or the arbitral tribunal puts down its decision in a particular field, so that the whole file becomes the award. It sets out both the claim, the response to the claim, the arbitral tribunal's reasons for accepting or rejecting particular issues, for accepting or rejecting particular evidence. It sets out everything, including the reasoning of the tribunal. That becomes the award. And when you enforce something, that is what is enforceable under the New York Convention. These things can be developed as part of an online dispute resolution platform. Now, this is just one suggestion. Different people can develop different online dispute resolution platforms. TMI can develop one. And these can become what people agree to, parties agree to in the future. In other words, rather than simply saying, I agree to arbitration by JCAA, interactive arbitration rules, you say, we will use the JCAA or the JIIART or the TMI arbitration dispute resolution platform to resolve our disputes. I think we need to develop, and we should be looking at these sorts of things. Not looking back to go back, oh, the way things used to be at pre-COVID-19. We should be looking forward.
Justice Anselmo, I have one question. When you talk about the platform inside the world arbitration, I mean the international arbitration, is it almost possible right now, or is it still developing standard platform which is used by all the users?
It should be capable of developer right now. Certainly with Japanese technology and Japanese know-how, it should be capable right now. I'm not necessarily suggesting that this is AI. We're not necessarily using AI for this. It's just a standard platform, an electronic file where people fill in various fields, and the arbitral tribunal from time to time replies, responds, gives directions, gives decisions in various fields. This doesn't seem to me very difficult. This can be done. Many different formats of platform can be done. Now, you read a lot in the all over in the internet about one institution or other developing an online platform for one-stop dispute resolution. But when you ask for details, what's this one-stop online platform? It seems to me all that's being talked about is simply a way of, it's like a social networking platform where you match up with a mediator or an arbitrator to deal with various aspects or all the aspects of a dispute. I'm looking for something more than that. I'm looking for an app which will actually produce an electronic file, which will actually, at the end of the day, be what is sought to be enforced. The whole of that will be the award, which will be enforced under the New York Convention. Look at it this way. Nowadays, a large component of costs in arbitration is the writing of an award. Certain people have a view of what an award is supposed to be, and they put in everything into the award. And so you have long, fat, sometimes rambling awards. Those are not cheap. They may simply be cut and paste, but cut and paste is not cheap. I'm trying to think of ways to cut down the cost centers of international commercial arbitration, speed things up. And I think development of competing platforms, not just social networking sites for between arbitrators and potential clients or customers, but some sort of platform that can be used as a tool for dispute resolution, that I think that can be done now. We don't have to wait.
Yes, it's a very innovative idea, and I totally agree. And also JIIART and other institutions cooperate and make some platform at the beginning. It's very important, I think.
I think with Japanese know-how, it should be possible to do it. The first prototypes may be clunky, problematic, but by the time you get to the fifth reiteration or so, it should be quite a good instrument and should have marketable value. I mean, it should be competitive in the market.
Thank you.
Thank you. So by accelerating the technologies, I think like the place of the arbitration is not so important in the future, and like more quality of the arbitrators or lawyers become more important. in that sense, I would like to talk about the variation or diversity of the arbitrators. So in these days, the arbitrators are most arbitrators are men, and there's less women, and in these days it is like more the social interest is have more in society have more interest in the diversities. So I would like to ask your opinion about how to increase the variety of arbitrators.
Thank you very much. That is an important question. Not just gender diversity, but diversity in the field of arbitrators altogether. Perhaps let me just say first one or two words about why diversity, especially gender diversity, is important in arbitration, international arbitration. When you deal with arbitration cross-border, it turns out that what is usually hotly in dispute are the facts. It's not really the law. The law is often well known and the principles are not in dispute. But what's in dispute are the facts. The most common sort of dispute is whether or not someone orally said something at a given time. One party says yes, the other party says no. Now, how are you as an arbitral tribunal, or how are you as an arbitrator, going to determine whether it's yes, someone said something orally, or no, someone did not say something orally? The only way to do that is on the balance of probability. It's not by demeanor, it's not whether someone speaks fluently or where someone gives evidence haltingly, because someone may be telling the truth, but may be nervous, and therefore comes out speaking uncertainly like that, but knows perfectly well what actually happened. On the other hand, someone may be a trickster and just speak very fluently. So the only way that the court or arbitrator can tell is on the balance of probability, looking at all the evidence as a whole. That means that you have to evaluate the balance of probability on the basis of your life, on the basis of your own experiences, education, your past. You, as an arbitrator, have to determine what was more likely than not to have happened given this entire context. Now, if it's only just men, or a very narrow society, narrow range of people who are determining this in an arbitral tribunal, it's going to be a very skewed view of life. The more diversity there is in an arbitral tribunal, the more accurate, I would suggest, is the ability of that tribunal to assess on the balance of probability whether something did or did not happen in fact, given the totality of the evidence. So that's why I think diversity is important. Now, how do we promote gender diversity? In particular, how do we promote gender diversity in Japan? Recent events, both in the news, unfortunately, in relation to the Olympics, suggest that there's still very much in Japan a male-oriented mentality. And one of the questions that has troubled me is how exactly to promote gender diversity in Japan, particularly in the future generation of arbitrators and future generation of international commercial arbitrators. Take one of my courses at Doshisha University. I've been teaching recently a course on investment treaty arbitration. There were 4 students in that course who attended my talk, my seminars, 4 female students, all very keen about arbitration, all highly motivated, all pretty good in English, and all who are willing enough, interested enough, so that when I suggested that they take part in the FDI moot to take place in Seoul towards the end of this year, they all agreed. Take some time out in order to work on this arbitration moot, this moot on investment treaty arbitration. Now, I keep asking myself, how are we going to make sure that these female students of mine will have a future in investment treaty or international commercial arbitration? They don't, some of them are intending to be bengoshi, some of them are not. But what prospects do they have, and how can we promote or enhance their prospects? And I think this is a situation where firms like yourself, TMI, your own firm, other firms in Japan, especially in Tokyo and in Osaka and Kansai, I think have some sort of obligation to take on interns, to take on students, even if only on a 2-week or a short-term basis, especially female students, to try to expose them to what it means to engage in international commercial dispute resolution. Give them an opportunity, give them a chance. I think that's very, very important in order to promote diversity amongst those engaged in international commercial dispute resolution in the future. I think that's very important. Otherwise, especially in Japan, where there's still very much a male-oriented thinking, gender diversity is not going to happen. You've got to make some positive efforts. And I think where the positive efforts should be led are the law firms, particularly established law firms such as TMI.
Thank you. I understand that it's very important to promote the diversity in Japan, or especially law firms. And like based on that practice, I like to move on to the other side, our clients. So if you give some advice to the Japanese companies which are involving in arbitration, what is important for them to conduct the international arbitration?
I think for this, to answer this question, we need to step back a little bit and look at the psychology of Japanese companies generally. Now, there's been a lot of literature, especially in the 1960s and 70s, about Japanese companies not going to litigation. If you have a dispute, Japanese companies between themselves, it is said, prefer to resolve those disputes through negotiation, possibly through mediation, but mediation is not well known, I think, in commercial disputes in Japan, but simply through discussion. So it is said that between themselves, Japanese companies will not go to litigation, and I take it that means they won't go to arbitration either. They prefer negotiation, so we may be able to develop international commercial mediation here in Japan, for instance, through the JIMC. So, okay, if we're looking towards arbitration or developing a sense of international commercial arbitration amongst Japanese companies, it's probably going to be amongst Japanese companies that do a lot of business, that engage in FDI, foreign direct investment, abroad. Japanese companies that have a dispute, therefore, with, for instance, a joint venture partner, a foreign joint venture partner in some other country. Now there, the preferred mode of dispute resolution is arbitration, because it is thought that you can enforce an arbitral award under the New York Convention in most jurisdictions in the world. In about 167, I think, something like that, jurisdictions in the world, you can enforce an arbitral award, an international commercial arbitration award. So arbitration is favored. The problem, I think, is that Japanese companies yet today, even today, do not quite have a good sense of what international commercial arbitration is about. And that may be because in the domestic scene, they're reluctant to go to arbitration, and just amongst Japanese companies, between Japanese companies, they prefer negotiation. But my experience suggests that they go to negotiation in foreign cross-border matters, up to a point. And if the other side, foreign party, is not reasonable, is not prepared to compromise, then they go off to a more formal means of dispute resolution, either litigation or arbitration. But some companies are familiar with this. A lot of other companies are not, particularly medium to small, micro, small, medium enterprises, MSMEs in Japan. So I think it is necessary, in order to promote a culture of arbitration, for institutions such as JIIART to talk more about what arbitration involves. What is a good arbitration? What would a good arbitration agreement look like? Where should you go for arbitration? Now, if you have a Japanese party and a foreign party, the wisdom is that if the Japanese party says, let's go to arbitration in Japan, JCAA rules, the foreign party will say, I don't trust Japanese arbitration, let's do arbitration in my country. The Japanese party will say, no, I don't trust arbitration in your country, let's go for a neutral third-party country. That's the wisdom. But some have suggested to me that based on their experience, if a Japanese company presses, if it has, on the basis of its economic bargaining power, after all, it's investing abroad, if it presses, it may be able to secure a Japanese seat of arbitration, a resolution of a dispute in Japan under, say, JCAA rules. So one can try that in order to bring arbitration to Japan. But in order to do that effectively, one has to know about international commercial arbitration, not just as a vague concept, but one has to know what is international commercial arbitration in Japan. What's the meaning? What are the advantages of the JCAA rules? How do you enforce an arbitral award? One has to know the details in order to have confidence in arbitration as a mode of dispute resolution. And I'm not sure that most MSMEs in Japan are really familiar with that at this point. And that's the difficulty. That's where JIIART and other institutions, the JCAA, have to market arbitration as an effective means of dispute resolution abroad, FDI. There is one further aspect, but we'll come to that, I suppose, in a moment. I would think that if Japan is promoting itself as it is now, as an international commercial dispute resolution, it's not looking just for cases involving Japanese parties. It's looking to attract cases from abroad that have no connection necessarily with Japan. In other words, think of what I just said. Parties to a joint venture want a neutral venue. Japan wants to be able to say to such parties from abroad, Japan is a neutral venue. We are very knowledgeable. We are arbitration friendly. You can resolve your disputes here in Japan, and we're happy to provide the facilities, the resources. We have the ability, the capacity, the judges, the arbitrators, the arbitration lawyers to help you resolve your dispute. Now that's a different problem. How does Japan attract business not related to Japan or Japanese companies to Japan? And that we can discuss if you in due course.
Thank you. Yeah, I think it's very important points too. And so, like, one of the reason is right now, the arbitration cases took place in Japan is not so big, not so much, and it's kind of difficult to experience international arbitration for the both Japanese companies or lawyers, or of course the companies not have any relation with Japan. And in such situation, what do you think we can do to increase the international arbitration cases, or we get more experience to prepare for the future increase, I hope, cases?
Well, that's a very good question. This is an exciting time for Japan as developing and to become an international commercial dispute resolution. I agree with you, it's not going to happen tomorrow. It's not going to happen next year. It'll take a long time, a long framework. Hong Kong and Singapore did not become international commercial dispute resolution centers in a day. They took, well, 10 to 20 years. And I think that's what we have to look at in terms of Japan. The good news is there are steps being taken now by the Japanese government, by stakeholders in Tokyo, Osaka, and elsewhere, in JIMC, in Kyoto, where I live. There are steps being taken to promote Japan as an international commercial dispute resolution center, particularly in the future. Steps are in particular being taken to look at, review our arbitration law in Japan and to reform it. The Gaiben Act, the Act for Foreign Registered Lawyers, has already been amended and has an innovative reform in the sense that shortly it will allow cooperative ventures between foreign registered lawyers and Japanese lawyers and bengoshi. All these reforms augur well for Japanese international commercial arbitration in the future. Now, to grow, how do we grow the work? We got to promote, we got to market, we got to tell the world that Japan is here, Japan is placed. At the moment, no one thinks of Japan as an international commercial dispute resolution. So one has got to go out, outside of Japan, and spread the word. One has to engage in webinars, in conferences, talking about the advantages of Japan as an international commercial dispute resolution. Otherwise, no one will know. Every opportunity you get, you got to talk about it. Look at what some of the advantages. Just yesterday, I think, The Economist came out with its list of the most livable places in the world. Auckland in New Zealand came out first, but surprisingly, perhaps, Osaka and Tokyo, Osaka in particular, came up as something like the second and third within the top 5 most livable places in the world. Osaka, for instance, because of its infrastructure, amongst other reasons, because of its connection with, let us say, Kobe, historic port city, its connection with its financial center resources, its connection with tradition, Kyoto and Nara, a very convenient location. There are many advantages to Japan and arbitration in Japan, but people don't know about it. So it's got to be marketed. You have a top-class judiciary, a judiciary that is knowledgeable and familiar with arbitration. The arbitration reforms are thinking about focusing arbitration-related cases to the Tokyo District Court, I believe, and the Osaka District Court, so that you will have knowledgeable judges dealing with foreign or foreign-related arbitrations if they should need supervision or assistance, judicial support here in Japan. But again, no one knows about that. No one knows about the ability of judges, of Japanese judges, in terms of arbitration. For the SICC, Singapore International Commercial Court, every chance I get, I talk about the work of the SICC in terms of its ability in arbitration. You don't see the same about people talking about the Japanese court, even though there is a lot of capacity, knowledge in the Japanese judiciary about that. So that's got to be promoted. Now, judges can't really speak about themselves, but Japanese lawyers, Japanese companies, when they go abroad, when they go to conferences, they can sing the virtues of the Japanese judiciary. Unless people know about this, no one's going to come to Japan. Most importantly, you've got to have capacity for the future. If we're looking in a 10 to 20 year time frame, the young law students today are going to be the arbitration lawyers and arbitrators of the future. So we've got to be building capacity in Japan today. There may not, as you say, be enough work today for everyone. But if we all focus on developing a market, and developing capacity today, nurturing the students who are willing to or interested in developing a career in international commercial arbitration, I think we can, but we have to be determined. We can make it. Now, we talked a moment ago about promoting diversity in students interested in arbitration. We also need to nurture those students who are prepared to go into or start a career in international commercial arbitration. Let's be frank. In Japan today, because of the demographics, it's relatively easy for a Japanese student to find a job. If you're a bengoshi, I think you can relatively easily find a job in a law firm. If you're not a lawyer, but you take a law degree, you go to the law faculty, take a law degree, you can readily easily find a job in some trading company or other. To attract a student who's keen to say, I want to do something different, I want to try to go into international dispute resolution, to say to that student, well, come on, take the risk. We got to do something to promote that. One way is, as I said, internships at law firms. Law firms should be more willing to take interns. But we got to think of ways to encourage this so that we will have Japanese lawyers, Japanese arbitrators in the future, 10 to 20 years, when these reforms that we are doing now, that are being done now, will take form. That's a major undertaking. And that requires a degree of perseverance amongst everyone. There's one further reform that's being discussed that would make a great difference. I don't think that people will come to Japan for international dispute resolution if they have to translate everything, the documents of an arbitration, into Japanese. Why would they use a Japanese seat? If there's a problem with arbitration and has to go to court, everything has to be translated into Japanese under, I think it's Article 74 of the Court Act. No one's going to do that. It's just an extra cost. It's just an extra inconvenience. Better go to Singapore or Hong Kong. If there's even a small reform, and this is being discussed at the moment, a small reform to allow documents at least, to be adduced in English in the Japanese court, where Japan is the seat of the arbitration, I think that would be a major step towards changing people's attitudes to Japan as a seat of arbitration, going to Japan for the resolution of disputes. And so I hope that that reform takes place. For submissions before the court, all right, fine, that can be done in Japanese. But for documents, especially the documents of an arbitration, including, say, transcripts, most of the time these international disputes take place in English, even though it may not be the first language of the parties. But because it's international and English is the lingua franca, it's in English. So if we don't have to translate, I think that would be a major step towards attracting people to Japan. We talked a moment ago about COVID-19 and the acceleration of remote technology. If, as I imagine, remote technology takes effect and everything becomes online in the future, then what will really matter is the quality of the judiciary at the seat of arbitration. Arbitration, international commercial arbitration, will become delocalized. You don't need a Maxwell Chambers. You won't need a fine set of a venue like in Hong Kong. What you'll need is a judiciary with a reputation for being arbitration friendly, for being cosmopolitan, etc., for being able to handle things in English. So I think that's an important step, promoting the judiciary and allowing documents to be in English.
Thank you. I think it's very important to the foreign companies to have interest in Japanese arbitration. So lastly, I'd like to ask if you have any message to the young associates who have interest in international arbitration in Japan. I'd like to know how they can improve their skills, or how can they prepare for the future cases?
I would suggest two things. One is to be brave. There are some risks involved. As I've just outlined, there are easier things to do. And we don't know, I can't guarantee that we will be able to track work for everyone in the future. I think there's a good chance we can if we work hard at it, promote it, actively, single-mindedly pursue it. But there's no guarantee. So one has to be brave. And to my students, to yourself, you're one of my students, I would say you got to be brave. The second thing is a little bit more unusual. And that is, going back to what I said earlier, how do I develop a sense of fairness? Japan can have bengoshi, no problem there. The problem is, how do you make that jump from being a young lawyer to being a young arbitrator? How do you develop that sense of fairness so that you go not just by the letter of the law, but by the spirit of the law? Not by the form, but by the substance of procedure. You understand due process. You have a feeling for natural justice. How do you do that? And my advice there, my advice to all my students, is you have to do two things, I think, at least. Or one thing, you have to travel. Now, travel means you can travel physically. It's a little bit difficult nowadays because of COVID-19, but you can travel physically and see as much of the world as possible. Experience the world at different levels. So you learn, to quote Homer, the minds and customs of many people. And you absorb that, and you have a cosmopolitan view of life. You can also travel, if you can't travel physically, you can travel in the mind. And how do you do that? You read widely. Too many students that I've encountered read just on the law or read manga, and that's all. You have to read widely in literature, science, history, whatever topics are of interest to you, but read widely so that you have a wide experience, either in the mind or through reading or physically, of life in its many forms. Life is not neat. The balanced probability in the law, determining that, is a very subjective thing, and you have to be open-minded. I think that's very important. And the time to do that, to build your capacity in terms of experiencing life, knowing life, so that when you encounter different people as an arbitrator, you're able to assess them with some degree of empathy, sympathy. How do you do that? You have to travel widely in the mind, and travel widely, if you can, physically. Gain more experience. All of this requires being brave, not just doing what everyone else is doing. So it's tough. But I think a lot of people are behind you. Professor Abe, Professor Ito at Chuo University, for instance, a lot of people that I've met at universities and the government in Japan are very keen to develop international arbitration and Japan's capacity there. So there's a support mechanism. It's a risk you take, but I think it's a risk worth taking. The rest is for you to develop a sense of fairness, a sense of justice. And that requires going outside, not just going outside of yourself, but going outside of Japan, going outside of the things that are comfortable to you in life.
Thank you for your message. I like to be brave, and in order to get a sense of fairness, I would like to experience many things from now on. So thank you for taking your time today. It was your answer, every answers to my question was very interesting, and it's very I like to keep your message in mind and want to do my best in the future arbitration cases which I will be involved in. So thank you very much for today's interview. Thank you.
Thank you very much for inviting me. Thank you very much. It was a pleasure.